distinguished panelists and participants. Bharati Vidyapeeth's Institute of Computer Applications and Management, BVI CAM, in association with Computational Intelligence Society, CIS chapter of IEEE Delhi section, Computer Society CS chapter of IEEE Delhi section, Technology and Engineering Management Society, TEMS chapter of IEEE Delhi section, System Man and Cybernetics SMC Society chapter of IEEE Delhi section, Communication Society of IEEE Delhi section, Consultants Network Affinity CNA Group of IEEE Delhi section, Life Member Affinity LMA Group of IEEE Delhi section, Inter-Society Relations IRS Standing Committee of IEEE Delhi section, Industry Relation and Special Interest Group on Humanitarian Technology Site Standing Committees of IEEE Delhi section, Region 10 of IEEE, in association with the Computer Society of India, Institute of Information Technology Professionals, IITP, ISTE Delhi section, and IETE Delhi Center as technical collaborators. Welcome you all to the IEEE IETE BVI Camp Technical Lecture Series on Harmony Beyond Heirs, Crafting Your Will to Prevent Family Conflicts. According to John Ward, it is easy to damage relationships when conflict resolutions do not work out. This simple quote indicates the sad truth of many families in the current times. This webinar promises to provide an insightful conversation that promises to demystify the often overlooked aspects of wills. This webinar aims to shed light on the significance of having a will, the nuances involved, and the profound impact it can have on the peace of mind for you and your loved ones, while also delving into the crucial role a will plays in preventing conflicts within. Understanding the ins and outs of estate planning is crucial for everyone, irrespective of age or professional background. A well-crafted will ensure that your wishes are respected and your loved ones are provided for, making it a cornerstone of responsible financial and personal management. Importantly, it serves as a powerful tool in preventing conflicts within families, promoting harmony and unity during challenging times. This webinar shall discuss its all-round perspective, including the real-time issues and challenges. I would first take this opportunity to welcome amongst us our distinguished panelists for the day. We are privileged to have amongst us a galaxy of experts. I would now welcome amongst us Professor M.N. Huda Sir, Director, Bharati Vidyapeeth's Institute of Computer Applications and Management BVI CAM, and Executive Vice Chairperson, IEEE Delhi Section, to address the participants with his inspiring words.
Good evening, one and all. I take this opportunity at the beginning to welcome all my valued speakers today, and also grateful to Mr. Daman, my friends, who keep on taking this initiative and connecting me with all learned eminent speakers. I also take this opportunity to welcome all my friends from various collaborating professional societies, including General Ajay Chandeleji, for this 142nd webinar series, which all of you know was started way back in May 2020 in the backdrop of COVID-19. Dear friends, in last almost 140 sessions, we have been talking about protecting IT infrastructure, protecting our knowledge repository. We have been talking about upgrading and making us relevant in terms of various professional skill sets. Today's topic is how best we can craft our wills so that our successors, our family members, should not find it difficult after us. That's also important. So today's session is primarily to protect our assets, which otherwise we normally do not care. And it's an important session for all of us. because many of us know whatever I have written on a blank page or maybe on a some non-judicial stamp paper, that is very good and sufficient for me. And then we are not there to take care of any problem which occurs at a later stage. So it is always better to make a foolproof system, make a well-drafted system. That is what is the purpose today. So I welcome you all and will request you that those who have not registered for any for our forthcoming sessions, kindly do register for their sessions as well. Thank you so much. Wish you all the best. God bless you all. And stay safe, stay healthy, stay vibrant, keep learning despite disruptions. And over to you, Dr. Ritika, please.
Thank you, sir. Thank you for the motivating words. With this, I shall now welcome amongst us our expert speakers for today, Advocate SP Jain sir and Damandev Sood sir with an e-bouquet. So welcome to the webinar.
Thank you, Dr. Saab.
SP Jain sir has been a gold medalist from Delhi University and Presidential Award winner 1980. He has been practicing in all Delhi district courts, state high courts, and Honorable Supreme Court of India since the year 1984, dealing with cases of all statures and different intricacies of law. He has served as keynote motivational orator, lecturer, and trainer on different legal platforms throughout India. He has been constantly engaged in conducting seminar, workshop, trainings, moot courts, etc. on various platforms. He has trained 10,000 plus individuals ranging from law students to top executives of insurance companies, banks, IRS, IPS, and other bureaucrats as well. Having written more than 10 books on different subjects of law, Sir has been imparting education to students since the very beginning of his career. We are honored to have you amongst us, Sir. We also feel honored to address another intellect for the evening, Mr. Damandev Sood, sir. Sir has over 38 years in the industry and over 18 years in the resilience domain. A certified international and corporate trainer with over 14,000 hours of training, teaching experience, achieving 100% NPS and holding over 13 copyrights. A CPD member, two of Sir's courses are CPD certified. He is also the author of 6 published books on resilience and has designed over 40 courses, including those for global entities like BCI, BCS, NECMA, etc. In his professional journey with corporates like TCS, Zansa, Continuity and Resilience, City Innovates, EY, HSBC, he has played various senior executive roles like principal consultants, group head, practice head, COO, CIO, VP, board member, program director, etc. He has traveled in over 20 countries. An international speaker, he has served clients in various industry sectors like government, IT, banking, financial services, insurance, telecom, marine, manufacturing, pharma, power, media, trading, etc. During his journey, he has also won multiple national and global awards and has also been inducted into the BCI Hall of Fame. As a LinkedIn invited contributor, he has contributed over 15 articles so far and is a top voice training and HR. Currently director at the one-person company DBD Training and Consultancy, he serves as an international resilience trainer and consultant, serving cybersecurity, operational organizational resilience, BCM, risk and crisis, and is the chair PR and P Standing Committee of IEEE Delhi section and IEEE Ambassador. I welcome you today to this session, sir. I would now request
Very
our
much.
guest to kindly enlighten the house. Over to you, Jensen.
Yes. Good evening to all the team members and all the participants who have joined. Today's session is regarding the drafting of will and the importance thereof. Now, as far as the will is concerned, it is a legal document, or you can say it is a legal declaration of a person who wants to have the fulfill their own desire after his death. Suppose a person has got movable or immovable property. It is applicable to both the properties. Either the properties are movable or immovable, and he is the owner thereof. Then he can dispose of these properties during his lifetime, but the operation of the transfer will take place after the death of the testator. Generally, there are three parties at the time of drafting the will. The person who is going to write the will, it is called testator, and the person who will get the benefit of the will, he is called the beneficiary of the will. And the third person is the executant, the testator, who is going to write the will. He can nominate or appoint an executant who is going to fulfill the wishes of the testator after his death. Therefore, it is very important document, and we should be clear in our mind at the time of drafting the will what is the importance of this writing the will. Firstly, as far as the conditions for writing the will is concerned, the person who is the testator, he must be a major person, and secondly, he must be of sound mind. These are two very, very essential conditions. And at the time of dispute or conflict, generally, in most of the cases, there are other grounds also, but most of the conflict or dispute relates to the 2 points that either he was not capable to write the will, execute the will at the time of its execution, or there was some force, coercion, misrepresentation, or that he was not of sound mind at the time of execution of the will. Therefore, it is very necessary that when the person is writing a will, if he is going under various ailments or diseases, then in order to avoid those disputes after his death, he may take a certificate from the doctor regarding his health that he is capable, he is of sound mind, and he is understanding the contents of a document. And when this certificate is to be obtained from the doctor, it has to be attached with the will also. Thereafter, this document, being the legal document, it does not require any stamp paper or court fees. It can be written on a plain paper, and the contents of the will must be very, very clear. There should not be any ambiguity in the words written in the will. Firstly, when we are going to draft the will, the name, father's name, or in case the married ladies or any lady is writing the will, if she is married, then her husband's name. In case of gents, his father's name, his complete address, his age, the date of the execution of the will. This must be written on the top of the will, so that the particulars of the person who is executing the will must be clear, and it is going to work at the time of raising any dispute by the other family members or outsiders. Secondly, the name, address, parentage, etc. of the beneficiary, that should also be very much clear at the time of drafting the will. At the time of drafting the will, it is not necessary that you have to devolve the entire estate to a particular person. you can distribute the movable or immovable property to more than one persons as per your own wish or desire. There is no such condition that the entire will has to be given to a particular person who is the beneficiary thereof. You can give one asset to one person, the another asset to another person. Therefore, there is no limit to the beneficiaries at the time of drafting the will. The third important condition is concerned as far as the drafting of the will is concerned. The executor who is going to execute the will as per the wishes of the testator, he must be a confident person of the testator who has got good faith, ability, and he can dispose of the properties of the testator after his death as per his desire, which is mentioned in the will. These are three parties which are to be mentioned in the will, and the other necessary condition for the validity of the will is there must be two attesting witnesses. At least two witnesses are required. If the witnesses are more than two, then there is no question can be raised regarding the attesting witnesses. These witnesses must be mentioned in the will, and these witnesses shall not be the beneficiary on whose the estate of the deceased is going to devolve. In case the attesting witnesses are mentioned in the will as beneficiary also, then the will still be valid will, but the beneficiaries, they will not get the assets or estate of the deceased even it is mentioned in the will. Therefore, the attesting witnesses must not be the beneficiary which is mentioned in the will. And as far as the witnesses are concerned, this is the most important part of the will, because at the time of dispute, these witnesses has to appear before the court, and they have to state that the testator had put his signatures or thumb mark in their presence. There are some confusion in most of the minds of the people that the witnesses must be aware about the contents of the will. But as far as law is concerned, the witnesses do not require that they should be aware about the contents of the will. If the testator wants to mention that I do not want to disclose the names of the beneficiaries even to the witnesses, then also the attesting witnesses can put their signatures, and the law does not require that the attesting witnesses must be aware about the contents of the will. You can put their signature, and at the time of dispute, if any raised by any of the members of the family or outsider, then the question will be whether the witnesses had signed in the presence of the testator, or it is also not necessary that both the witnesses must be present at the same time. One witness may come today, another witness can come tomorrow or thereafter, and the most important part is either the testator must sign in the presence of the witnesses, or he may say to the witness that this is my thumb mark or my signature. This is enough, and this is the only requirement of law. You have to mention the name, parentage, and the address and age of the witness, and at least two witnesses must be there. This is the legal requirement. And thereafter, the regarding the importance and of this drafting the will is, this document is called testamentary document. Testamentary document means this document will come into operation after the death of the testator, meaning thereby the testator can change the will at any number of times during his lifetime. There is no restriction as per law that he cannot write the will again and again. He can draft the will, he can sign the will as a testator at any number of times. He can change as per the requirements, which is the complete desire of the testator. As far as the registration of the will is concerned, it is not necessary at all. The registration of the will is not necessary. And in case, suppose there is a registered will. Today, the testator had gone to the office of the registrar and he had executed the will. He had got the will registered in the office of the registrar. And he comes after that to his house and his mind changes due to any reason. Then he writes another will. And the subsequent will, that is not a registered will. Many times this question arises, which will is going to prevail? Whether the registered will is going to prevail or the last will, which is unregistered, is going to prevail. The law is very clear on this subject also, that the last will is going to prevail whether it is registered or it is not registered. Therefore, the testator can execute number of wills during his lifetime. He can change the contents of the will at his own desire or wish at any number of times, and the last will come into operation after his death. Now, many times this question has also been in the minds of the persons, that when it is not necessary to get the will registered, then why we are going to get the will registered in the office of the registrar? It means there must be some additional benefits in case the will is registered. What are those benefits of registration? We can discuss it, that in case the will is registered, then in case suppose it is lost, then also you can obtain a certified copy of the will from the office of the registrar. Secondly, you cannot raise the objection, or even if you are raising the objection regarding the soundness of the person, then the court is going in favor of the registered will in case the will is registered, then it is a presumption of law that the man was in his senses, he was in good health, he was understanding the contents of the will. Therefore, you will get the benefits of sound mind of the testator in case the will is registered, because the presumption is in favor of the testator's good health. Thirdly, many times this question arises that the testator had expired, and after his expiry, the family members got the thumb impression on the will and they have manipulated it as per their own convenience, own desires. In case the will is registered, then the court is not going to consider this type of objection that the will was got thumb impressed after his death. Similarly, there is a provision in the Registration Act, Indian Registration Act, that suppose the testator, because there are so many challenges to a person who has got the ownership of movable or immovable property, especially when the testator is weak due to disease or illness, then he faces the consequences that in case I am going to disclose the names of the beneficiaries, then the persons who had not been given the share in the assets or the estate, they may harm his health, they may kill him. Therefore, during his lifetime, he wants that my desires, my wishes has to be fulfilled. I want to distribute the assets as per my own will or desire. But in case it is going to be disclosed during his lifetime, then there is imminent threat to his life that the non-beneficiaries, they may harm him. They may shunt him out from the house. Therefore, there is a provision in the Registration Act that the testator can go to the office of the registrar and after sealing the will in the envelope, he can deposit it with the registrar without even disclosing the contents of the will to the registrar even. And sometimes this question arises that the will is going to be in picture only after the death. It is going to be operated after the death of the testator. Then suppose the person after drafting the will or writing the will, after getting it signed, deposit the same in the office of the registrar and he expired. Then how the family members or the beneficiary will get the benefit of those wills? Because it is a secret document, even the family members are not aware whether the testator had written the will during his lifetime or not. Therefore, in such cases, in order to solve this problem, the testator can nominate or engage an executant. He can inform him that I have already deposited the will in the office of the registrar. The family members has to be informed after my death that I have left the will and it is deposited in the office of the registrar. Or you can say to any of your loyal friend or family member that you can go there and take the will, because during the lifetime of the testator, the registrar is not going to open the will. In case you want to get the benefit of those deposited wills, then you have to show the death certificate of the testator that the testator has expired. He had during his lifetime had deposited the will in your office. This is the death certificate, and now you have to open it, or you can file a case also before the court, and the court can summon the will from the office of the registrar. And in case the summons are sent by the court, then the registrar will open the will and get the contents registered in his office, in his books, and he will produce the copy of the will before the court. Therefore, this is the procedure to safeguard the interest of the testator so that his life cannot be in danger. His wishes are going to be fulfilled without any risk. Similarly, there are so many other technicalities while you are going to draft the bill. These technicalities, if solved during his lifetime, and the person who is going to draft the will, he informs the testator that you have to write the will in this manner, then many disputes can be avoided or it can be solved. One of such problem is many times the testator wants that his will must be registered during his lifetime, but he is not in a position to go to the office of the registrar. Suppose he is on the bed, he is not in a position to go to the office of the registrar and get it registered. Then in those circumstances, whether the will can be registered or not. For that also there is a provision in law, in the Registration Act, that you have to move the application before the registrar and you have to annex a medical certificate that the testator is not in a position to visit to the office of the registrar. In that case, by taking some nominal charges, deposit of the nominal charges in the office of the registrar will visit at the house of the testator, and in that manner the will can be registered even without visiting to the office of the registrar. You can get the benefits in this manner even without visiting to the office of the registrar. Now, as far as the question is concerned, suppose a person, he is owner of movable and immovable properties, and he did not write the will, then what will happen? What will happen to the estate of the person who has not written any will during his lifetime? Actually, in such circumstances, it is in law, it is called the death was intestate. Intestate means without writing a will. The person had expired, he had left movable or immovable properties. He did not write the will, execute the will during his lifetime. Now, what will happen to those properties? Who is going to be the beneficiary of those properties? In those circumstances, the property or estate of the deceased regarding the movable or immovable properties, that will be distributed as per Hindu Succession Act. Then in those circumstances, even those persons to whom the testator did not want to give any property due to any reason, they will also get the rights in those properties. Then the distribution of the assets of the deceased or the testator will not be as per the wishes of the testator. That will be as per the rights which are mentioned in the Hindu Succession Act. Therefore, it is very much clear in one's mind that if you want that there should not be any dispute in future after the death, and the distribution of the movable or immovable properties shall be as per the wish or desire of the person who is the owner of the will, owner of the assets, then it is desirable and it is important also that you have to write the will during his lifetime in order to save many conflicts or disputes. There is very nominal charges. If you are going to get the will registered, it is the value of the stamp duty is not as per the as per the value of the properties. The registration charges are very, very nominal. The condition is only that the testator must go, or in case there is any difficulty, you have to move the application. In that case, the registrar will visit your house. You have to take the witnesses in the office of the registrar. You have to deposit the registration charges, and thereafter you should be clear in your mind that in case the will is registered, there is no conflict or confusion that you cannot change it. You can still change it as per your own desire at any number of times. Many times the clients ask me why a person can write so many bills during his lifetime. It is going to make the conflict, and why the registration of the will is not made compulsory. In this regard, if we are aware about the object and purpose of the legislation, then as per the object, the testator, who is the owner of the assets, he can change his mind as per the prevailing circumstances. Today, my one son is taking care of me, and I write a will and make him the beneficiary in the assets. And tomorrow, I had a conflict with that son. In case the registration of the will is made compulsory, then the testator has to visit many times in the office of the registrar. Similarly, in case, suppose the person, the testator who is the owner of the properties, he is sleeping and he feels pain in chest and he thinks that it is my last time. At night hours, how he is going to manage to get the will registered? Therefore, in order to give the benefits of all these things, the registration of the will is optional. It is your wish if you want to go to get it registered, or if you are not going to get it registered, it is your will. It is your desire. But the last will is going to prevail. It should be clear in every month's mind. Many questions I have faced during my entire practice. And generally, all the person says, no, we have already got the will registered, therefore we are not in a position to get it changed. Or if we are going to change it, then we have to take the permission of the registrar, or we have to go for the cancellation of the registered will, then only we can write it. There is no such requirement. There is no need to cancel the registered will. There is no need to take the permission of the registrar. The only thing is you have to write the will, and in case you are going to write multiple wills, then it will be better. It will be better that you can mention in your will that I revoke my earlier wills. Even if you are not going to write it, still the last one is going to prevail. But in case you are going to write that I am revoking all my previous wills and this is my last will, then it will be better option for the testator. And many times the questions arises in the court that the testator had given all the assets to only one beneficiary. Suppose there are 5 family members and the testator has got the wife, sons and daughters. In his will he writes that all my assets has to be devolved to my wife. Then the question arises whether the sons, daughters and other persons can raise this dispute that they are also the owner and they have got the entitlement of the share of the property left by the testator, or they have got the equal rights after the death of the testator. In this regard, the law is very much clear that as far as your self-acquired properties are concerned, whether these properties are movable or immovable, you can dispose of these properties as per your own wish. It is not necessary that you have to give equal share to the wife and sons and daughters. It is not necessary. This is completely as per your own convenience, as per your own desire, as per your own wish. If you want to give it to the trust, you do not want to give any share, any property to any of your family members, you do not have any faith upon the family members, you can give it to the trust also. You can disown all the family members also. Even if they are going to challenge it, the court is not going to give you any relief, because whatever the self-acquired properties are there, you can distribute it as per your own convenience. Even if the family members are going to raise any issues, they are going to challenge the will, then also the court is not going to favor them, because it is you and you only who can decide to whom the properties after your death will devolve. During my discussion with Mr. Daman Dev, last week we sit together, he had raised very valid question which I can discuss here also.
Let me attempt to ask that.
Yes, it was regarding the nominee, and he will raise the question, and I am going to give the answer for that also, because these are the relevant questions. When you are writing a will or when you are going to deposit the amount, you are purchasing the shares and other securities, then many times the banker asks certain questions and you are going to give the names. the person is not actually aware what is the meaning of it. We can discuss it as per the time availability of the time and the question raised by Mr. Dhawan or by any other person.
Great. Thank you very much, Mr. Jain.
Yes.
We do have some time, and I'll attempt to do a little bit from my side. So, as a layman,
Yes. Please.
I'll attempt to summarize not what you said, which is correct, but what I understood. And then you can comment upon that whether the understanding is correct. But in simple terms, as a layman, as I would have understood, the topic is very important. There are four parties in writing and executing a will. In our corporate world, in management system terms, we call them interested parties or stakeholders. So there are four stakeholders: a testator, a beneficiary, a witness, and an executioner. Testator is the person who is writing the will, who owns the assets. Beneficiary is the one who will get the money or other assets. And we have just understood that this can be any person in the world. A beneficiary can be any person in the world, not necessarily the legal heirs.
Yes.
Or direct or indirect family members or blood relations. Witness, two are required to execute a will, and a good practice is that the witness is not the beneficiary.
Yes.
Otherwise, the beneficiary may lose the benefits. That's the impact.
Yes.
So good practice is that the witness and beneficiaries are different. Executioner, in my terms, is the caretaker of the will.
Yes.
So simple terms, as I said. The testator, executioner, and witness all must be major and in good, sound mind. While the beneficiary may be a minor and may be in unsound state of mind also. That's great. All of these people, four interested parties, must be properly identified in the will. Name, address, age, sex, gender, etc. Very good. The last will prevail. A person can write as many wills as he or she wants, but the last will prevail. And it is not mandatory to get the will registered.
Yes.
Thank you very much. With this, with your permission, Mr. Jain, I'm attempting to pose a case to you.
Yes.
And I look forward to your views on that.
Yes.
Some of those actually have been clarified while you're talking, but for the benefit of our audience, perhaps we will repeat that. Even if you have already answered, maybe a minute again on that. So the case is that there is a person who can be male or female with two kids. It could be one also, but I'm saying two kids, and I'm saying there is a male and female kid also. If we take this to be a male person, then we take in the case the wife is also alive currently.
Yes.
Okay. So is it mandatory that all four means two kids, sorry, all three, two kids, which is a combination of male, female, I'm saying in this case, well,
yes,
could be both sons and both daughters possible, and the wife of the person also. We are taking the person, the testator is a male person in the case. Can equal distribution of, sorry, is it mandatory that all three must get equal proportion? If the distribution is unequal, can this be challenged? What happens during the period the case is in the court of law? Can the assets be consumed by the beneficiaries during this period?
Yes. As far as the contents of the will is concerned, the wish of the testator is going to prevail. It is not necessary at all that there must be any equal distribution.
Okay.
Even if the testator do not want to give any share to his wife, even to the kids also,
That's possible.
he can entrust the entire estate to any fourth person, to any trust, or to any friend, or to any other person in the world. You cannot say that the rights of the wife or the kids are there. What to say about the equal distribution?
All right.
When even the rights are not there.
Okay.
It is the sole wish of the testator. He can distribute the amount or the assets as per his entire wish. You cannot force. Secondly, as far as the stay is concerned, generally in such type of cases, unless there is some substantial issue involved in it, the court will not stay the operation of the will. If you are going to show very substantial issues raised by you, then the court can stay the operation till the pendency of the case, but that is very rare. Meaning thereby, in case the stay is not given by the court, then the beneficiaries of the will can get the benefits. They can sell out the properties also. They can use the properties as per their own wish. You cannot say that by mere filing the case, the operation of the will is going to be restricted. It will not be restricted until and unless specific order is there.
Thank you very much, Mr. Jain. One aspect or characteristic of the will, which you had mentioned, was that the will should be kept secret also
Yes.
from the beneficiaries.
Yes.
There's a chance that if it's known, if it's told to beneficiaries, so I'll take a case once again, assume it's you and me. Fine. We are related. I feel, I believe, I think that I should get that property that you have or your assets. So you should write will in my favor. But you disclose that it's not written in my favor,
Yes.
then I'll be unhappy. And there's a possibility that I stop taking care of you.
Yes.
There's a possibility that I can actually get you killed or kill you. It could be to that extent.
Yes.
But at the same time, if you give me, if you tell me, if you open that you have not given to me, I may be unhappy and I may stop taking care of you.
Yes.
But at the same time, if you tell me that you have given it to me in your will, I may still stop taking care of you, that I am not sure that it will come to me. You have already written your will in your will, that is shown to me. How do we resolve this?
Yes. First of all, suppose I am going to disclose that I had written a will and you are the beneficiary and your name is mentioned as one of the beneficiary in the will. Then subsequently, I can change it. Suppose after disclosing this, you are not going to take care of me. Then subsequently at any point of time during my lifetime, I have a right to change my will at any number of times. Therefore, the law is very flexible. In case till my death, you are not going to take care of me, then I had got the options that I am not going to give the benefits after my death. I can change the contents of my will. I can deposit the same before the registrar, even without disclosing it to the family members or to the beneficiaries also.
So that's a strong or positive point or a way out in your hands,
Yes,
right? That
because you can change the
can
contents
change
of the
it.
will at any number of times.
Great, great. Thank you very much. One more, and perhaps another one after that before we come to closure. The difference between the registrar and the court. So what we are discussing today is will, writing or executing a will. It is not mandatory to get it registered. But if someone wants to get it registered, it will be in the office of the registrar.
Or
But any challenge or dispute will go to the court.
yes,
Am I right?
Yes.
If you can again maybe speak in your terms, in your own words, explain this to us better than me.
yes. in the registration of the will is only before the registrar. The court is not involved in that. Generally, we took the office of the registrar as a court.
कोर्ट जा रहे हैं जी.
Yes, but it is not a court. It is office of the registrar. It is none of the business of the registrar to resolve the dispute. If any dispute is there, only the court can dispute. Only the court can pass the order, or it can resolve the dispute. Therefore, there is a lot of difference between the office of the registrar. He is the executing side, and it is the judiciary side. Completely different roles are there. His work is only to see whether the person who is the tester has appeared in my office or not,
All right.
whether two witnesses are there, whether he is owner of the property or not. He is not concerned with this.
All right.
But at the time of resolving the dispute, the court is going to look each and every aspect of the will, and the contents itself will be taken care of, whether the person who is the testator, he is real owner of the property or not, whether the will is registered or not. That is also not necessary. In case you do not want to get it registered, then also it is good. Even without visiting to the office of the registrar, you can write the will. Therefore, even there is no necessity that you have to go to the office of the registrar. Therefore, these two things are completely different. You cannot mix it that office of the registrar is equal to the court.
Okay.
That is executive side, and this is the judiciary side.
Good.
Ultimately, the role of the judiciary is superior. They are going to resolve the dispute.
Thank you very much. The last one. Last week when we were planning the session, this session, it came out, even if it not related with will execution
yes.
necessarily, but the question about the nominee.
Yes, yes.
Almost everywhere, whenever, especially opening a bank account or otherwise creating any other assets, we are required to write a nominee. So who can be the nominee and what is the role of the nominee?
Yes. Generally, there is very much unawareness, or even the bank officials or the other persons, they are not going to tell you what is the role of the nominee. They will just ask to whom you want to appoint as nominee. Then even if you are going to ask from the bank officials what is the role of this nominee, why you are asking about the name of the nominee, they are not going to give you the clear picture. As far as the law is concerned regarding the nominee is the person who can receive the amount from the banker. In case the account holder has expired, and during his lifetime, at the time of opening or subsequently, if you appointed any person as a nominee, then you are saying that this person can come to the court after my death to receive this amount which is lying at the time of my death. But he is just the custodian of this amount. He cannot retain this amount as the owner of the property after the death of the account holder. Ultimately, the legal heirs, they are entitled to get this amount, or in case the will is left by the testator, the bank account holder, then all the proceeds which are in the custody of the nominee after the death, which has been received by him from the bank, then the nominee has to give the entire amount as per the contents of the will. Or in case he has died intestate without leaving any will, then the entire amount has to be given to the legal heirs of the deceased. He has got no right to retain this amount as owner of the property, owner of the amount, owner of the balance which is lying in the deposits of the bank, shares or other deposits. Therefore, we have got no knowledge about the role of the nominee. We generally think after the death, in case the nominee is appointed, then he will receive this amount and he will the owner of the property, and he will retain this amount. He cannot retain this amount.
Cannot retain, cannot consume.
No question of consumption. The legal heirs, in case of intestate, they are entitled to get this amount even from the bank or from the nominee. Or in case the will is left by the account holder, then the person who is the beneficiary in the will, he is entitled to get this amount from the nominee. Meaning thereby the role of the nominee is only to take this amount from the bank, nothing else. He cannot retain, he cannot consume, he cannot utilize or use this amount for his own purposes.
Thank you very much. While closing the session, or attempting to bring this to close before I hand it over back to Dr. Ritika, I would like to create a scene which we have seen many times from Bollywood movies. I'm not sure about Hollywood movies, but Bollywood movies, Hindi movies, and especially the old ones, that the person is on the deathbed. This is where the scene starts from. Then he or she dies. And all of a sudden, at that time, a person enters the scene. सेठ जी की वसीयत ये है, उन्होंने वसीयत लिखी थी, and this is what he is saying, there is a will this person has done. So how does that happen? Who is this person?
Yes.
Who knows this person? Who appoints this person?
Yes. As I said earlier, the person can be engaged or appointed or deputed by the testator during his lifetime. And that person is called the executant. It is solely as per the wish of the testator. The person who is loyal to the testator, he is going to appoint that person. And after his death, his role will start, because the operation of the will is after the death of the testator. During his lifetime, it is not going to be operated, it will not be effected in any manner whatsoever. Therefore, the moment the death of the testator is there, the executant will take all the properties and he is going to divide it or distribute it as per the contents of the will, which is written by the testator.
So, my apologies, I'm interrupting once again. But if the executant dies before the testator,
Yes.
and then testator also dies, who knows about the will? Who knows what is to be done?
Yes, many times it also happens. I am taking a step ahead. Suppose the testator appoints an executor also. And after the death, the executor says, I am not interested.
Right.
I do not want to involve in such type of disputes. My own work is there. I am a busy person. I do not want to indulge in such type of activity. This can also.
Right.
In those types of conflicts, when the dispute will arise, the court can appoint a person. He is called the administrator.
All right.
Then, because the court cannot compel the person who is not interested to distribute the property as per the will, as per the contents of the will written by the testator. If you are refusing, it means the court is not helpless. The court will appoint the administrator. That person is, if the testator is appointing, then it is called executant or executor. Or in case the court is going to appoint, then it is called administrator.
Administrator. Okay.
Then the administrator will distribute the property as per the wish of the
All right.
testator.
Okay. Right. Thank you very much, Mr. Jain. With this, I would like to hand it over back to Dr. Ritika.
Thank you, sir. Thank you for the enlightening deliberation. And I'm sure this insightful session has enlightened the participants about the importance of will. Most of the questions have been taken by you and Daman, sir.
Kritika,
Yes, sir.
they have clarified their doubts, but what about the rest of us?
Yes, sir. Most welcome.
No, but do you have any time now?
Yes, sir. Yes, sir. You can surely ask a doubt.
Okay, then Mr. Jain.
Yes, sir. Yes, please, sir.
uh, acquired part of the will and hereditary part of the will. When I write a will, do I have to specify my assets, or I can give a formula 50% to wife, 25% each to my two sons?
You can give this type of distribution, but it may create dispute later on. In order to avoid the dispute, you are writing a will. Then when you are writing a will only to avoid the dispute, it is beneficial if you are going to distribute it by giving the name of the property, the measurement, the whether it is registered or not with the office of the registrar, which portion goes to which person, what
Mr.
is the
Jain,
address
but
of this
I
property.
may survive the writing of the will by 30 years. I will acquire many more assets. Can I
Yes.
keep changing my will so often? So
No, no.
in such a case, a formula would be better.
No, no, you can. There is no such question that you cannot write in this manner. But it may create some problems that this was not acquired at that time and it was not the wish of the testator. Then the questions may arise. You can still distribute this
Sir, I will
these type
say
of assets.
assets as on the date of my death.
Yes,
I will not, there's no question of acquired now or acquired later. Assets on the date of my death to be distributed as per formula, because it may be impossible for list continuously modifying my wills to mention all the equities that the assets I acquire or assets that I disacquire. Okay. So 50%, 25%, 25%, this should suffice.
now so, I may give you one example for that.
No, let's just say yes or no.
Yes, you can, you can, you
Okay.
can.
Now come to the hereditary portion of it. As you are aware, that hereditary portion, where there are no disputes in the family, comes from generation to generation, right? My grandfather had two sons, one daughter. He had 100 bighas of land. On his death, both sons got 50 bigha each. Nothing was given to the daughter because that was not applicable at that point of time. You come now, one more generation. One son has three children, one son has two children, couple of daughters. Now, can the daughters now, in retrospect, claim their share of the hereditary assets?
Yes, 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 please. There is one Hindu Succession Act,
Are we aware of that, sir?
and in case the ancestral property is there,
I'm just saying, is the new law for daughters applicable with retrospective effect?
this law came in the year 2005,
Yeah.
and the question in that case arises whether the property which has already been distributed prior
Yeah.
to the amendment of the Hindu Succession Act,
That is what
whether
is retrospective. So please tell me, is it applicable retrospective? Yes or no?
no, 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 it is not the distribution which had already been taken place that will not be revived.
Thank you. Thank you.
This,
That was
this
the
may,
question only about this portion. And about the, you see, if you are not having an executant, or even if you are having an executant and you're not registering your will for the reasons that I stated, what is the best place to keep your will?
this is to be deposited with the registrar
No, no, if you are not
without
registering it,
registration. Without registration.
can I keep it in the bank or a custody of a chartered accountant or lawyer?
Then you have to inform to the person that this is my will, and after my death, you have to disclose it that my will is there.
Right?
You can deposit it with your friends, with your lawyer, with your chartered accountant, with your family members, but at least you must have the faith that after my death he is going to disclose it.
Can we make original copies of the will? Original copies
Original copy, yes.
means the number of, keep with one friend, keep with another friend, identical ones.
Yes, 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 yes. There is no question of making copies. You can have 10 copies and you can distribute it to 10 of your friends.
Right. Thank you. Can we have your number, sir, for queries later on?
Yes, 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 please.
We will ask Ritika to share your number, WhatsApp
Uh,
number. Thank you so much for these clarifications.
Yes, sir. Thank you, sir. Thank you very much.
Thank you so much, Chandel sir. That was wonderful. I think all the queries have been taken over today in a wonderful manner. So thank you so much, SP Jain sir, for answering and explaining things so simply. It was an excellent session. All our attendees have thoroughly enjoyed it. Uh, I would now request Professor Emin Huda sir to kindly present a certificate to SP Jain sir as a token of memento for this wonderful session today. Huda sir, please.
Thank you, madam. Thank you, Dr. Sir.
Huda sir,
Thank you,
you
sir.
are on mute.
I don't think he's there.
Sir, he's there, but he is on mute. I am not sure if he's able to hear us. So,
Well, the certificate is signed, so it may be taken as given.
sir, I would request you to do the honors in that case, please.
Mr. Jain, sir, thank you very much. It was a very
Thanks a lot, sir.
enlightening conversation with you.
Thanks a
And,
lot, sir.
we are grateful.
Thank you, sir. Thanks a lot, sir.
Thank you, sir. I'll also request you to kindly honor Daman sir with a certificate.
Yes, Naman sir, very insightful questions from your side. I cut
Thank you
them
very
from
much.
my list, only ask the questions which remain. Thank you very much for this
Thank you.
interesting conversation.
Thanks a lot.
You can share my telephone number, mobile number. Yes.
Yes, sir. We also have a small e-memento for our guests. I would again request Chandel sir to kindly do the honors.
Yes, to who?
Sir, sorry, just a minute. I'll just share the e-memento.
Okay.
We have small e-mementos because it's all virtual. So even we
Right.
have e-mementos.
Yes, Mr. Jain sir.
Thank you,
Once
sir.
again,
Thanks.
thank you
Thanks
very
a lot.
much. And
Thanks a lot.
I'm sure we will utilize your expertise on some other occasion as well, as also at some other conference. We are
Anytime.
organizing a conference at Sharda University on 17th of February. We are an NGO called Public Police NGO, and this is about senior citizen welfare. And this aspect of writing will, people think they are very smart, but they don't know there are so many intricacies which you have just explained. So I'm not sure whether you will be able to spare some time to be part of this conference. It's a full day conference.
I was lecturer for 1 year in Galgotia University.
So once I get your number, we'll contact you if you are free for some time on 17th.
Yes, sir. Yes, please. Sir.
Thank you. And with this, we'd like to hand over this memento to you. Thank you.
Thanks a lot, sir.
Thank you, sir. And there is another memento for Daman sir also.
Yes,
Chandel sir,
Mr.
please do the honors.
Daman Sood sir, please accept this memento from
Thank you very much.
IEEE BVI CAM technical webinar series, and look forward to future interaction with you. Thank
Thank you
you.
very much. Thanks a lot.
So once again, a big thank you to our distinguished experts for the day, SP Jain sir and Damandev Sood sir. I would also give a special thank you to our panelist, General Ajay Tandel sir, who has had wonderful queries with our experts and has also done the honors to commemorate the experts at the end of the session. So thank you all, dear panelists, as well as a big thank you to all the participants who have been part of today's session. The feedback form fill link for the session has already been shared in the chat window, dear participants. Please do not leave this meeting room without generating your own certificate of participation for this knowledgeable session today.